So everyone is very welcome to workshop 3, which is going to be led by Wayne Bates on health and safety rights and responsibilities. You may, for those of you who were in the previous session, Wayne did speak at the end, but just to introduce him officially, Wayne is a national negotiating official for the NASUWT, and he's based at the union's headquarters. Part of his role includes responsibility for UK-wide health and safety. He also negotiates with some of the largest multi-academy trusts in England and with the governments in Guernsey, Jersey and the Isle of Man. Before working for the NASUWT, Wayne was a physics teacher in a large secondary school in Birmingham. And I'd like to welcome you here today, Wayne, and thank you for all your work in organising and setting up the seminar today with Delma. And I will hand over to you now. Thank you.
Hey, thank you, Shauna, and good afternoon, everyone. I'll just quickly start sharing my screen. Okay, so this session's on health and safety rights and responsibilities, and really the aim of the session is to look at the health and safety legislation that we've got, look how it applies to teachers, and look at what entitlements that legislation gives teachers and health and safety representatives. Also, we'll look at what the responsibilities are, particularly for employers, and what they are expected to do, and we'll go into a few areas to give a little bit more detailed advice. Now, there's literally hundreds of pieces of health and safety legislation, and we're only going to be able to have time to look at 4 in detail. So we'll have a look at the Health and Safety at Work Northern Ireland Order 1978. We'll look at the Safety Representatives and Safety Committees regulations, the Workplace Health, Safety and Welfare regulations, and we'll also have a quick look at the Management of Health and Safety regulations. Of course, the last one was what Jeff touched on in the last session as well. Before we get into the nitty-gritty of the legislation, I think a key point to make right from the start is that the legislation applies to all workplaces and all employees equally. There's no difference between state or independent schools or full or part-time or substitute teachers. It applies to everyone equally. And much of the legislation also applies to pupils and also to volunteers. And volunteers often get neglected by employers. They kind of, in employers' minds, they fall into a little bit of a crack. But they are covered by the legislation, and employers need to consider volunteers as if they were paid employees. So, looking at the Health and Safety at Work order in a little bit more detail, well, this was the piece of legislation that really, it's the foundation of the entire health and safety system that we've got. So it places duties on all employers, whether that's a steelworks or a school, doesn't matter. The duties are there. And the duties really are that employers must ensure, as far as reasonably practicable, the health, safety and welfare of all employees and non-employees in the workplace. So that includes assessing risks to health and safety and taking steps to reduce or eliminate the risks. And as I said earlier, non-employees could include substitute teachers, certainly will include volunteers and pupils. And I said before, volunteers do tend to fall through the gap a little bit. And recently there was a court case that the HSE brought in Bedfordshire, I believe, in England, where a volunteer at a football club went up to repair, it's a fairly small football club, non-league football club, went up onto one of the roofs of the stand to repair a leaking roof, fell through the roof and sustained some very, very serious injuries. And even though they were a volunteer, there was no risk assessment in place. So the club got fined quite a substantial amount for that injury because they hadn't taken account of the risks. Equally, there's been a school recently in Cambridgeshire, I believe, where they had an after-school event in the evening. It was a dark evening, it was this time of year, and one of the attendees to that tripped over a low wall on it was a non-lit stretch of pavement. So they tripped over this small wall, sustained serious head injuries, and sadly died as a result of that. And again, it was due to the fact that the employer had not taken account of the risk and not done everything reasonably practicable to safeguard people against it. And of course, in that case, it was a visit to the school site, but it could easily have been a teacher or a pupil that tripped over that wall and sustained that injury. The other important thing to note is there isn't a qualifying period for this. I mean, lots of employment law, there's, you have to work for so number of weeks or number of months before the regulations, the protections kick in. That doesn't apply to any of the health and safety legislation, really. There's no qualifying period. As soon as you step foot on the premises, then that applies, or indeed not necessarily set foot on the premises once you're involved with that employer. So an example would be, for instance, if you're off-site doing a school trip, the employer's responsibilities still apply, and it still applies as soon as you're involved with that employer. One thing that an employer can do is they can kind of delegate the tasks of under the Act, but they can't delegate the responsibilities. The responsibility always rests with the employer. So in the case of a school, they can delegate the responsibility for the day-to-day management to the head teacher, but the responsibility for that still sits with the employer. Now, the health and safety work order doesn't just put responsibilities on employers. It also puts some responsibilities on employees as well. And that is, it's essentially common sense, really. First of all, that you've got a duty to take reasonable care for your own health and safety, and that of other people who may be affected by your actions at work. So, for instance, not allowing big piles of paper to pile up, which could be a fire hazard, not as I've seen many times in schools, not propping a fire door open with a fire extinguisher, and things like that. So making sure that your own actions don't endanger your own health and safety or the health and safety of other people around you. It also states that you've got to cooperate with your employer where you're working. So that includes participating in any health and safety training or instruction. They've got to provide it free of charge, mind you, but you have a duty to engage with that. And it's also around following risk assessments. And failing to follow a risk assessment that the employer has put in place can put you in a difficult position, particularly if then an accident arises as a result of that. Now, you must be told about any risks that are connected with the work. You're then responsible to carry, to make sure you follow any instructions in that. You're also expected, can be expected to follow any control measures, but they've got to be told to you, and you've got to be informed of that. And any special skills that you needed to do the job. Particularly that last bit applies particularly for substitute teachers. So if you're going on to a placement, you should be told what's expected of you and what the requirements are. You should also be told how to raise any concerns about your health and safety. Again, that applies to all, but particularly with regard to substitute teachers if you're going into a new place of work. And again, you can be expected, if you see something, to raise that and to inform managers or school leaders of any issues that you have noticed in the school. Second piece of legislation that we'll look at is the safety representatives and safety committees regulations. Now, this is also known as the Brown Book. And this really sets out the position of rights and responsibilities of health and safety representatives. Also sets out the requirements and how employers should engage with them. It states the functions that health and safety representatives has, which generally include representing members generally on health and safety matters, investigating accidents in the workplace, any near misses, looking at any other potential hazards or dangerous occurrences within the workplace. If you get complaints from members, to investigate those. Any issues that are raised by members around their health, safety and welfare, and also to be consulted by management, by managers on health and safety matters such as risk assessments. Now, the regulations also give health and safety representatives the right to inspect the workplace, and you can do that at least or once every 3 months. And also, if there's a health and safety committee in existence, to attend the health and safety committee. Now, the regulations also make it absolutely clear that although health and safety representatives have additional powers compared to ordinary employees, they don't have any additional responsibilities compared to other employees. They must take reasonable care of themselves, not put anybody else at risk, same as everybody else, but there's no additional responsibility there, and they can't be held responsible for any missed issues. So if a health and safety rep does an inspection of a school, and let's say there's a tread missing on a staircase, and they don't pick that up, there's no comeback for that. There's no liability. There's no issue there, because it's still the employer's responsibility to find and deal with health and safety issues within the school. Under the regulations as well, health and safety representatives are entitled to time off to undertake their functions. That time off has to be paid, and it is as much as is necessary. And this is the real difference between a health and safety representative and a workplace representative. Workplace representatives are entitled to reasonable time off. Health and safety representatives are entitled to adequate time off, so as much time off as is necessary. And that's really a key difference between the two. So health and safety representatives actually have more power than workplace representatives, as their position and rights are enshrined in law in a different way and a much more formal way than workplace representatives. Now, going back to the second part of the regulations, really the safety committees part of it. If one doesn't exist in a workplace, if 2 health and safety representatives request a committee, then the employer is legally obliged to set one up. And the health and safety committee will have various functions, and that will include looking at the statistics that are coming out of school, so sickness, accident statistics, looking at any risk assessment, looking at any issues, looking at trends, considering reports, considering the report of the health and safety representative, things like that. But another key aspect of the committee's work is that for it to carry out the role effectively, it has to have the necessary information. And that's not constrained by GDPR. So we have got lots of examples of employers seeking to restrict the amount of information that they give to either the committee or to the health and safety representative, and citing GDPR as the reason why information, say accident statistics and things, cannot be provided. And that's ridiculous. As long as sensible measures are taken so that people can't be personally identifiable or identified through the data, then accident data, risk assessment, things like that should be provided to the committee and to the health and safety rep. And the need for adequate oversight in a workplace, and the health and safety committee can fulfill that function from the employer's point of view, cannot really be overstated. And I think Jeff mentioned the case earlier in the day, where Luton Borough Council was fined over £100,000 after following a sack on a teacher by a pupil. And one of the failings that the judge drew attention to was the lack of oversight in that case by the local authority. Indeed, even though the court accepted that no concerns had been raised to the council, the court determined that the council also did not seek out any concerns as well. So there's an important aspect there of oversight. Is not just being responsive, it's being proactive. And the health and safety rep can really get involved in that and push that narrative and make sure that the employer is doing exactly what they should be. And of course, the employer should welcome that approach, because anything that makes a school more safe or safer is a good thing. Accidents and incidents, particularly serious ones, can be very disruptive. They can be very damaging to the individual involved, but to the school in general. So anything that can help to promote good health and safety in a workplace should be welcomed by either the school management or the employer, or indeed both. Now, the third bit of legislation that I mentioned earlier is the what's commonly known to referred to as the welfare regulations. And this sets out minimum standards that applies again to all workers, whether it's a steelworks or a school, but it really does set that minimum standard. So for a start, it says that every workplace should have adequate toilets and washing facilities, and in this case adequate means enough for those that can be expected to use them. So people shouldn't have to queue for long periods to go to the toilet. Where possible, there should be separate facilities for men and women, or failing that, rooms should have lockable doors. The facilities should be clean, and to help achieve that, preferably surfaces should be tiled or covered in a suitable waterproof material. There must be a supply of toilet paper, and for female employees, a means of disposing of sanitary items. The facilities have got to be well lit, have hot and cold running water, and enough soap or other washing agent. The basin provided should be large enough to wash hands and forearms if that's required. And there must be a means of drying hands, so paper towels or a hot air dryer. And suitable facilities must also be provided for disabled workers. Drinking water has to be provided, so it must be free from contamination, preferably from the public water supply, although bottled water dispensers are acceptable as a secondary supply. It's got to be easily accessible, and there's got to be adequate supplies taking into consideration the temperature of the working environment and types of work activity. So if it's a hot weather, that's probably a consideration the employer should have, to make sure that everyone's got additional access to drinking water. Should be a suitable seating area for workers to use during breaks. Needs to be clean, located where food's not going to get contaminated. So in most cases in a school, there's no risk of contamination of food, but there is in certain areas, so science labs, technology rooms, things like that. So so teachers must be provided with an area where they can go away from that. There must also be washing facilities nearby and a means of heating food or water for hot drinks. And that area must also maintain good hygiene standards. Temperature must be reasonable without the need for special clothing. And if reasonable comfort cannot be achieved because of hot or cold processes. Again, that doesn't really apply in most school aspects. All reasonable steps should be taken to achieve a temperature as close as possible. Now, there are specific or school-specific rules in addition to these, which I'll come on to in a bit later. Sufficiently clean means that workplaces should be regularly cleaned, and we know through the COVID pandemic that has taken on a greater significance. There shouldn't be an accumulation of dirt or rubbish be allowed to accumulate, and any spillages or deposits need to be removed or cleaned up as fast as possible. Suitable seating needs to be provided. If you can do the work sitting down, then a chair has to be provided. Workstations should be arranged so each task can be carried out safely and comfortably. And also sitting alongside these regulations are the display screen equipment regulations, DSE regulations, which do apply to teachers. I know a lot of schools get into arguments whether teachers are display screen equipment users or not. Teachers use laptops, they use computers all the time, and there really shouldn't be any question that staff are DSE users, DSE operators. And therefore their workstations should have a DSE assessment undertaken. And that should cover things like the keyboard positioning, the use of the mouse, whether the seating position is acceptable, adjustable chairs should be provided. Is the monitor position accessible? Does the monitor do what it should be? Does it flicker? Is it free from glare? It also covers the working environment as well, so things like lighting and heating as well. The other key aspect of the DSE regulations is it specifies that if you are a user, as I said earlier, teachers are DSE users, then an eye test should be, an annual eye test should be provided by the employer. And that doesn't mean, of course, that the employer has to organise eye tests for everybody on site. What it can mean is that somebody can access an eye test and then claim the cost of that back. But that right to an eye test is enshrined in legislation. Now, just wanted to touch on this aspect, this school-specific aspect. So there is a document called the Northern Ireland School Building Handbook, and this really does go beyond the requirements of the welfare regulations in a lot of areas. And they are extremely, the handbook is extremely detailed. So it does look at the minimum size of the overall site, what features have to be in the site, what facilities have to be on site. There's detailed guidance on the features of classrooms and different guidance and different requirements for different subjects in a secondary school, for instance. The minimum number of size of sanitary facilities for pupils and staff are specified in this, alongside minimum and specific lighting requirements. Now, one of the most useful aspects is in respect of temperature. So whilst the welfare regulations merely state that temperatures should be reasonable, there is a suggested minimum of 16 degrees in most areas, but it is only suggested. The building handbook and the building standards go into far more details with lower limits, which vary from 18 degrees in classrooms and dining rooms down to 15 degrees in gyms. They also actually go into quite detailed guidance on ventilation requirements and state where mechanical ventilation is required as well. So they do go into an awful lot of detail, and that can be really, really very useful, because it does build on, it does go beyond what the general regulations state. Now, from a health and safety perspective, all teachers, and including substitute teachers, should be clear of the items on that slide. I won't go through all of them. For most teachers, if you're in a school, this is going to be common knowledge. So you're going to know where the toilet is. You're going to know what the arrangements for break and meal times are. Hopefully know what the fire and evacuation procedures are. But if for substitute teachers, it is really important that that they're informed of this on their arrival at the school for the first time. So if you're at a new school, first day of placement, these are the type of things that should be explained to you and should be given to you in some kind of induction. For all teachers, though, it is important and required that any new health and safety issues are communicated to you, and any new or updated risk assessments are consulted on and shared. And that's particularly true with regard to potentially violent pupils. So if a pupil is potentially violent, then risk assessment should be done, and that should be shared with all relevant staff. We touched on the case of the Luton school. There's been numerous other cases before. There was one where I think it was in the Northwest some time ago now, but there was a pupil that had shown the potential to be violent. The school had correctly done a risk assessment. They put a behaviour plan in place. That was fine. But they determined that the only people that needed to be shared with was teachers who actually taught the pupil. What happened was that another teacher came along this pupil in a corridor who was misbehaving. They went to correct the behaviour, as they would with any pupil. Because they weren't aware of that specific risk assessment, they didn't know that there were specific control measures and specific things that needed to be done in relation to this pupil. And unfortunately, that ended up in a very serious assault by the pupil on the teacher. So it is really important that the risk assessments are shared with relevant staff. Equally, if a risk assessment isn't relevant, then it shouldn't be shared, or it doesn't need to be shared. So, for instance, if there's a risk assessment around, I don't know, operation of the fryers in the canteen, in the catering area, that only needs to be shared, obviously, with the catering staff that are going to use it. Although there's no problem sharing it with everyone, the danger is that if you share everything, then you start to get to a situation of you can't see the wood for the trees. And the danger, of course, there is that people start to ignore and not read the risk assessments that are important to them. Moving on, now Jeff went into quite a lot of detail around these earlier, but these really are the management regs really are what brought in the risk assessment process. So these date from 2000, so they've been in place for 21 years. So the risk assessment process is nothing new, but you'd be forgiven for thinking it was brand new, particularly at the start of the pandemic. The knowledge of employers and many school leaders with regard to risk assessment was pretty poor. I think things have improved markedly since then, but it did show that there was a general lack of knowledge, a general lack of appreciation of the risk assessment process. So I won't go into specific issues with this. All I'll say is that it does specify that a risk assessment has to be done for any hazard where the employer employs more than 5 people. It must be written down. It also does specify that risk assessments have to be carried out for pregnant staff. So that is actually written in specifically, that as soon as an employer becomes aware that someone's pregnant, then a risk assessment must be undertaken. That is not an optional extra. As I said, there's lots of other pieces of legislation that are around. I could spend a whole afternoon going through them all, but I won't bore you to death by doing so. But I will just mention a few more. So the first one is RIDDOR, so the Reporting of Injuries, Diseases and Dangerous Occurrences regulations. And that really says that if there's a serious incident, it has to be reported in a nutshell. So if there's a death, it has to be reported to HSE&I. If there's what's called a reportable injury, and that includes things like a bone fracture, other to fingers, thumbs or toes, if there's an amputation, if there's a serious dislocation, so of a shoulder or hip or knee or something like that, loss of sight, either temporary or permanent, if there's somebody has an electric shock, or if there's unconsciousness caused by something, particularly either due to asphyxia or exposure to something harmful. And also, and this does occur occasionally, not so much in schools, but it can happen on school trips. So if there's any other injury that leads to either hypothermia or heat-induced illness or to unconsciousness requiring admittance to hospital, then that has to be reported too. And it is very rare for a school situation to include that. But there has been instances where things aren't, such as Duke of Edinburgh expeditions, where either the weather hasn't been assessed properly, or it's the weather has taken an unexpected turn for to either become very poor weather or indeed very hot weather, and there have been cases of pupils and staff being taken ill, and that would be something that would need to be reported. The other thing that has to be reported under RIDDOR is that any accidents that lead to an over 3-day incapacitation of a worker. So if somebody's unable to work for more than 3 days after the day of the accident, and that includes non-work days. So if you have an accident, let's say on a Friday, and then you're still not at work on the Monday because of that accident, that would be the 3 consecutive days. That has to be reported as well. And again, there was a case recently where somebody was actually sent to prison for 28 days, an employer, because they failed to make a RIDDOR report. So that is very important as well. Asbestos, unfortunately, asbestos is in a lot of schools, but the asbestos regulations essentially says that must be managed, it must be inspected, it must be surveyed, there must be an up-to-date survey. We'd say that's basically every 3 years, and there must be a management plan as well. That management plan should be available to all staff. Schools that do this right have it on the reception desk. It should be freely available for anyone to look at. And it also says this is where schools tend to fall down. One, that any accessible asbestos should be labelled. And we have issues with schools saying they don't want to worry people about asbestos. But it is quite clear that if you've got, if the wall or something or a ceiling is constructed using asbestos, it must be labelled. And the other thing is that if someone's liable to disturb asbestos, then they must have awareness training. And again, that's something that schools are not great at, yet it is in the regulations. That is one of your rights under the regulations, to be told where the asbestos is and how to recognise it. Now, if in your school the only asbestos is in the boiler room and the boiler room's locked, and there's no reason why a teacher should go down there, then there's no reason under the regulations to do awareness training. However, if there is asbestos that is potentially accessible, then it should be subject, there should be some kind of awareness training. And there was a case a few years back where there was some kind of ball game being played in a hall. The ball actually went under the stage in the hall. Teacher went down there to get the ball back. That area was full of asbestos, and they disturbed it getting the ball back. And that was a direct result of not being, one, informed where the asbestos is, and two, not being given awareness training. Moving on, fire safety regulations. That says basically an employer must carry out a risk assessment. They must review that regularly where there's any significant change. It covers making sure that there's a sufficient firefighting equipment, exit routes are signed and maintained, what the procedures are for evacuation, the requirements to have drills, and also that all this has to be provided to employees. And then COSH, the Control of Substances Hazardous to Health regulations, really covers all our most chemicals. Now, it's most relevant for practical subjects, particularly science, where you've got some, quite nasty chemicals being used, but also, perhaps design technology, perhaps arts to an extent. But it also covers lots of the materials that we used in cleaning. And this has been one of the issues throughout the COVID pandemic, where enhanced cleaning procedures have been put in place, and teachers have been expected to undertake cleaning without being given training, without being given a risk assessment, and that is very clearly contrary to the COSH regulations. Of course, our position is that cleaning is not a duty for a teacher. Therefore, there's no need to give teacher training in how to clean, because they shouldn't be doing it in the first place. That really is the end of my presentation. Hopefully it's been useful. As I said, I could have spoken for many hours about regulations and various things, but I really would have bored you all to death. But I'll happily answer any questions if there are any that have come up.
Yes, Wayne, we have one from Stephanie, which I believe would link into the basic health and safety entitlements. Stephanie has said that they are losing their porta cabin that is used as a staff room in their school. It leaves a lot of staff without a staff room. It has been suggested that staff use their cars for breaks. Where does this stand with their rights? The principal has said that the EA said that the contract for the temporary staff room has been taken away, and there are no other rooms that can be used, as the original room is now a classroom, and Stephanie's school is a special school as well.
Well, it doesn't really matter whether it's a special school or not. Every worker has the right to somewhere where they can take a break. That area must have access to, to be able to heat up food, must have access to water and hot water for hot drinks. So, I mean, telling you to use your car for breaks is just, sometimes I really do wonder what employers are thinking of when they put this out. I mean, just one thing that immediately comes to mind is, first of all, what if you don't drive to school? Where do you go then? But there's lots of other aspects to this. First of all, I mean, it's not brilliant weather at the moment. It's fairly cold out there. So going to a car is not going to be suitable. Even worse than that, if you expect people to go and use their car, they're going to start running their engine. Most school car parks I've seen are very close to classrooms. So that then introduces issues around poor air quality in the classrooms, particularly if the exhaust fumes are then going into classrooms. So it really hasn't been thought through, this. So I think in this case, we need to push back and say, no, that the regulations, and to be fair, I'm pretty sure this is in it's not just the welfare regulations. I'm sure this is in the building handbook as well. We need to push back and say, no, you're the employer. This is what the law says. This is what your handbook says, and you've got to provide it. If the contract for the temporary staff room, the porta cabin, are taken away, get another one if that's the solution to the issue. But if you don't get any joy, if you don't get any success, please come to the NASUWT and we can support you.
Thank you, Wayne. Stephanie, I hope that answers the question. And I was expecting perhaps a follow-up to what we were speaking to earlier. We have a question in from Roisin in relation to the risk assessment being carried out on large gatherings like exams. If the principal finds that the risk of transmitting COVID is not significant and members are still concerned for their safety, can they still be made to supervise these exams, or do they have a right to say that they don't feel safe?
Right. I mean, the first question is, on what basis does the principal believe that the risk of transmitting COVID is not significant? What is their public health qualifications? What is their epidemiological qualifications? Also, I think that it's, well, what is the, again, it comes down to the risk assessment process. What is the rationale for going through? Why can't we change? Remember, it's what the employer, in this case the principal, can do that is reasonably practicable. Now, if members are still concerned for the safety, there are certain parts of legislation that we can fall back on, but they are far from a silver bullet. But I think in this case, if the risk assessment is carried out and it hasn't been carried out effectively, or we think there's deficiencies in there, that's where we need to collectivise the action or the response. So that's probably where you need to get in touch with the NASUWT, and we can start to collectivise around that. So it may be that we can negotiate something different. It may be that a complaint to the HSE&I might be in order. It may be that we have to look down more of an industrial response. But I think in that case, a collective response is probably the best way. So please get in touch with the NASUWT, and we can move that forward.
Lovely, Wayne, thank you. I don't see any other questions coming through. No. And again, just a request for the PowerPoint, so we will get that sorted. Yep. And sent out to participants later. Okay, that is brilliant. We have gained back some time again, which is fabulous. And so we will end now at 2:15 and be back for 2:30 for our final session of the evening, which is on safeguarding awareness for substitute teachers. So a wee 15-minute break, and we'll see you back then. Thank you.